It's a neat building.
Saturday morning. Yeah. Saturday morning, and I said,
Sorry.
should you guys like
Slow.
Okay. We're ready to start. You ready to go? I didn't get to check the sound. I couldn't get that slide. Do you know how to do it? Like, because I went arrow down and it just wouldn't play anything, but these are working.
Okay, so that's fine. We'll just go through them.
I don't know.
Well, I'm glad to see that building.
Is it like a place where you stand, like what we're talking?
I don't know. She said she started the recording, but I don't know. I don't see the camera. That's the problem. So I'm not sure how that works.
But it would make them fun to find out if they can see you.
Yeah.
Mm-hmm.
The camera's right up there, right?
So,
Is there a,
Can you see us, Nebraska City?
Yes.
all right.
Okay.
Okay.
Cool.
They can see us. Okay, we just can't see ourselves. That's fine.
And did they start recording yet?
Yeah, I think she hit the recording.
Okay.
All right, you ready? All right, good evening, everyone. My name is Micah Moravik. This is Daniel Segura, and we're going to talk to you a little bit about trademarks tonight. We're from the University of Nebraska Entrepreneurship Clinic. We provide legal services to people in the community here in Lincoln and in the surrounding communities in Nebraska. And hopefully we'll be able to tell you a bit about trademarks, give you some information that could be useful in your business going forward, and answer some questions that you might have, and perhaps raise some more questions that you might not have thought of before. All right, so let's get started. All right, so first of all, just a little overview of what we're going to talk about today. We're going to go over what a trademark exactly is, some of the different types of trademarks that you can get, and some of the processes of going through the federal registration, which is going to be the focus of this presentation, and then also some of the trademark challenges that you may face throughout the process, and then even after you may have a trademark. All right, so what is a trademark? Immediately when you see these logos up here, you have an immediate association with a particular company, with a particular product, with a particular service. You see the Adidas logo up there, you think clothing, you think shoes. You see BBC, you think television programming with British accents, those sorts of things. So the goal of a trademark is to essentially create an association between a certain mark, a certain word, a certain logo, and a company or a source, so that when people see this mark in the future, they can think, oh, I know that company, I trust that company, here's the product or service that I'm going to get from them and what I'm going to expect from them. So trademarks are intellectual property. Intellectual property includes copyrights, patents, and those kinds of things. They're things that you own, but you don't actually have a physical thing to hold and to keep. And that makes them a little bit more complicated to keep track of. If you have a plot of land, it's easy to keep people off of it. You can just push them aside and say, this is mine, you can't come in here. However, if you have an idea as an intellectual property, it's more difficult to keep people off of that and to enforce your property rights in that particular thing. A trademark in particular is any artifice indicating the source of a good or service. So again, it's protecting that association with that particular mark and a particular good or service. There are different mark formats. You can have standard character marks, which are just words, company names mostly, slogans, that kind of thing. You can have a design mark, so a logo or anything else that could associate with a company. You can have sound marks. For example, when you hear the 20th Century Fox drum roll, and the initial thing when you go to see a movie, you think that's 20th Century Fox. That's a registered trademark. There are other types of trademarks. You can trademark like how things look. If you see a Pizza Hut restaurant, you kind of think, yeah, I'm pretty sure that's a Pizza Hut, just based on the building design. Basically anything that you can associate between a particular indication and a particular good or service. When you have a trademark, it gives you the exclusive right to use that mark within the appropriate class of goods and services and within that particular geographic area. So what that means is essentially you have the right to protect your mark and to prevent anyone else from using it in a way that would confuse the consumer into thinking that this product actually comes from your company. So what's the point of having a trademark? What's the point of going through this complicated process and paying the fees to get a registered trademark? If you see, this is a top 100 ranking, just a couple of them, of the top brands in the world. As you can see, these brands are worth a lot of money. For the most valuable asset that some of these companies have is their brands. If you ask the CEO of Coca-Cola whether or not he could keep their secret formula or keep their brand, he's probably going to say the brand, because it's a lot more work to go out and get all of that goodwill and get all of that customer association than it is to actually have the good product. So trademarks are pretty important, and they're actually worth a lot of money, and they have a lot of value that they can add to your company to protect that association and to help customers identify you in the future and continue to use your product or service. So why do you want a protection from this? Why don't you just go about and have that association and just let people do what they want? You can see on the screen here, when you see that, you immediately think that's the Apple logo, but that's not quite the Apple logo. So if you see another company using this logo, they're kind of trying to get into on that Apple's market, the goodwill that they've created, try and like trick consumers into thinking, well, this is an Apple product, I'm going to buy this, even though it's not. So if you have a trademark, as Apple does, you can go ahead and prevent other people from doing things like this, to prevent your brand from being confused with copycats like the Pear company here. And even if they aren't doing it knowingly, even if they're just starting a company and they've never heard of your company before, you can keep people off of using this similarly confusing trademarks and just making sure that that association between the mark and your product and service is protected, and that you can make sure that that stays intact, even though other people might try and get into similar areas. It also protects your brand from dilution. When you see a lot of the top brands, you immediately think of the company and you immediately think of that product or service. And so if other people are using similar things, you can see how it might kind of dilute that and make customers think a bit before they actually associate with your company. And so having a trademark helps protect from that as well.
Okay, and now I'm going to talk a little bit about, from a broad perspective, the different kinds of trademarks that you can have either registered or just natural rights. These are not mutually exclusive. And to better understand what this means, as we said, a trademark is intellectual property, so it's not tangible. These are more like the rights associated with your trademark. The trademark could be the same exact trademark, but depending on how you registered or what you did with it, you could have any one of these or even multiple of them. So for example, common law, if you had any of the other three rights, you would still also have common law. That would be like the default. And for the international one, you would actually need federal registration as a prerequisite. So they're not mutually exclusive. I just want that to be clear as I go through these. And I'm going to go through each one of these four broad sense, and then we're going to focus mainly on the federal registration, since that's one of the ones that's more popular, and it kind of opens the most doors. So the first one we'll talk about is common law trademark rights. What does this mean? Well, this is the default. If you are using a trademark and it meets the basic definition of a trademark, it's an artifice indicating the source of goods or services, and it is not exactly like Apple's trademark. It's not the pear that looks exactly like Apple's. It's a valid one. It's not one that they're going to sue you over. Then anyone with that trademark has common law rights to that trademark. You don't have to register. So this new mark can say it's Joe's Tacos. If there's no other Joe's Tacos and that indicates where these tacos come from, well, that has common law rights. And as long as you build a restaurant called Joe's Tacos and you're doing business as Joe's Tacos, you don't have to do anything else. Your trademark to Joe's Tacos is protected. So no registration required. It does require continual deliberate use, and this is true for all trademarks. You have to continue to use this trademark. You can't set up shop as Joe's Tacos in a little stand and then you tear it down a week later and you don't use it for 10 years. Then you lose the trademark. That doesn't count anymore. You can't say, oh, I had Joe's Tacos 10 years ago. I haven't used it since. Well, that won't count. And it's also the limitation of common law trademarks is both that the evidentiary function of registering is not there. You would have to prove something like, I was using it for 10 years. If you had a register of some sort where people can see that you've been using it consistently, well, that helps other people know, but some people might be like, have you really been using that for 10 years if you claim that you have been using that trademark for 10 years? And then it's also limited by geographic area. As we have talked about, as Micah mentioned, trademarks are limited to a geographic area, and common law, it would be based on what the court would say, what the court in your state would say. So if anyone challenged your trademark, well, we say you have common law rights because the court would say, yeah, you have been, looking at the evidence, they would see, yes, this person has been using that trademark, but they would narrow it down to, well, you've only been using it in, say, Lincoln, so you only have the right to use this trademark in Lincoln, and you can't enforce that trademark in people living in Des Moines because that's not the geographic area that your common law rights extend to. So now we'll move on to state registration. Well, so say you wanted your trademark to expand beyond just the city that you've been using it in. Say you're like, well, maybe I'll move my business from Lincoln to Omaha or even to Scotts Bluff. What if I wanted it all over Nebraska? Well, you can get a state registration. For example, in Nebraska, you can file an application with the Secretary of State. It's always a governmental entity in that state, and that would give you protection over your trademark throughout the entire state of Nebraska. And there would be special requirements. It's not quite as easy as just using your trademark. You would have to do all those things that you would have to do to get common law right, but you also have to file a $100 filing fee with your application to the Secretary of State, and you would have to renew it every 10 years for another $100. And these fees are kind of substantial, but not quite as much as the federal registration, which we will talk about. So what are the good things and the downside of state registration? Well, it is only limited to the state. So once again, you couldn't enforce your trademark rights to someone who has a similar trademark in Colorado. They could have an identical trademark, but if they're using it in Colorado, you got yours in Nebraska, well, you only have a Nebraska state registration, so you can't force them to stop using that. And different states have varying levels of protection. So Nebraska would be comparable to a federal registration in all but geography. It's more narrowed. But some states might only give you limited years protection where you couldn't refile. They might say you can only file these certain kinds of trademarks. So it really depends on the state. And so you would have to be familiar with the state you wanted to get that registration in. And so the third kind of registration is the federal registration. We're going to spend a lot of time in the presentation talking in the specifics about the application, but broadly, you register with the U.S. Patent and Trademark Office. This was an agency created by Congress, so this is a federal law thing, and you get protection throughout the entire United States. So think about that difference. Instead of filing with your state Secretary of State and you get protection in your state of Nebraska, now you could get protection throughout the entire United States. If someone's using a similar trademark in Washington, D.C., you can send them a letter and say, hey, stop using my trademark. So that's the big benefit here. So the last registration we'll talk about is what they call international registration. It's a little bit of a misnomer. It's complicated, so I'll try my best to describe it. Basically, all trademarks are territorial, and what that generally means is national. So an international registration is not like you get a trademark right that is international, because international law is kind of a fuzzy thing. It's mostly based on treaties and what one country will acknowledge from another country. And there are many mechanisms and international law and agreements that can help that process. So for example, the international classes were created by the Nice Agreement, and that's named after Nice, France. I'm sure it's a nice agreement, but it's named after the city. And so in 1957, they established that. And what that allowed is, Micah talked a little bit about classes. That would be how your trademark is categorized. For example, there's a class, international class for restaurants. And this would be separate from the international class for goods that sell food products that might even be similar to restaurants. But that is a way to classify the trademarks and to show, well, these trademarks could be similar, but they're in a different class. So that's okay. We want to give everyone the right to use similar trademarks as long as they're in not confusing classes. So international classes are one way to differentiate between the classes of trademarks. And so that was established by many participating countries. They formed that agreement. And then afterwards, there were many Madrid treaties that set up the Madrid Protocol system. And what this does is participating countries that sign these treaties, if you have participants that have a register in one country, they can send another application to the World Intellectual Property Office, and that will basically forward their application and translate it into the laws of the other countries, or at least help that process. So for example, if you would first have to get your registration here in the United States, but then with an extra application fee and an application to the WIPO, then you could choose which countries you want your registration to also be in, and they would help you through that process. What this helps you do is you have a single application. You don't have to know the language of every country you want your trademark to be protected in. You don't have to get a lawyer. You don't have to get a lawyer in each country to know the law for you. The office will help you in that and setting up an application for each one of those. Now, each country still has their laws, and your trademark would still have to meet all those requirements, but since many of the countries have similar requirements, the ones that have signed on to these agreements all have the same international classes, for example. Often you can have one trademark that also transfers to another country through these means. So for example, you would have to pay the fees for each country, but obviously, if you were rejected by that country, you would not have to pay. But an example that I have here is if you wanted a trademark in the UK, Japan, and Israel, each one would have its own fee that is different from the other country. But then there would also be a basic standard WIPO fee of $653. And this fee would stay flat across the board no matter how many countries you added. So say you added 12 countries, well, that would really increase the benefit, because now they have done a lot of work for you in translating these applications to different registers. And obviously this has its limits. As I said, each country could still have different laws that would reject your trademark, or say there's a trademark already there in that country that's very similar to yours. In that case, you probably would have to get a lawyer to see how you can get your trademark to be registered there. But overall, this is a way to lower costs if you're wanting to expand your trademark into larger international markets. So now I'll return back to the federal registration. This is what we'll spend most of the time in this presentation talking about. What are the benefits of federal registration? Well, first, it preempts similar common law and state law registrations. So as we said, it has the broadest geographic range, and trademarks are always based on who had it first, who was starting to use that trademark in business first. But they are limited to that geographic range. But for example, if you had a federal registration and you filed before someone else was using a similar trademark in another state, well, your federal registration would preempt them from using that trademark because you've already covered the entire nation with your trademark, so to speak. And this constructive use through the U.S., this would amplify all the same common law benefits that we talked about. So when Micah talked about the benefits of trademark, of identifying your goods and differentiating them, of giving people notice that you have a trademark that has these symbols or these signs or these sounds, the federal trademark allows you to search online for who has a registered trademark, and so then people are on notice. So it amplifies those rights that you had by giving more people notice and giving you the power to prosecute those who are infringing on your trademarks throughout the whole country, and that allows you to prevent dilution of your brand. Say, as I mentioned, the Joe's Tacos example, say you had Joe's Tacos in Nebraska, and now you have a federal trademark. That allows you to stop a Joe's Tacos in Iowa, which is probably a really terrible restaurant, and lets you stop them from diluting your brand and making people think, oh, Joe's Tacos isn't really that great. You're like, no, my Joe's Tacos is the real Joe's Tacos. You can't be using Joe's Tacos because you're making me look bad. So that's one example.
Even though they paid Iowa to be in Iowa.
So if you have let me be clear, good question. To be clear, if you had the federal trademark and then they started using a similar trademark. So you were there first, that preempts them from, they can't even do that. They can't get an Iowa trademark. If they did, it would be invalid. But if they did do that before, because they're first in time, they would have a right only in Iowa. You see?
So they're not out there Iowa trademark.
Right, but the federal trademark, that would preempt anyone from getting a state trademark anywhere else if you were first. Yeah. And then the federal system is a prerequisite for the Madrid system. So you need your national trademark, and then you can expand to international markets. And so it's the most flexible in that sense. If you had a state trademark, well, you'd also have to get a federal trademark before you can get to the international system. So that would double your costs in a sense. So it's the most flexible. And lastly, you get the R for registered on your goods. So say you had a character mark, it has your Joe's Tacos, you could have the little R right there that would signify to everyone who sees it that, oh, this person has a federally registered trademark. Don't mess with them, so to speak. Okay. So we're going to give you, I'm done with the Joe's Tacos. So we're going to give you another hypothetical. Micah and I, like young men, let's just say we're into wine and beer and we want to start a business, and we're like, okay, well, what's going to sell? Well, people like Merlot wine. I mean, people sell it in boxes. I mean, they must really like that Merlot wine. And light beer, I mean, that's the most popular beer. So how do we make the ultimate wine and beer combo? Well, I present to you Merlot, and it is the combination of Merlot wine and light beer. And now I'm going to pass on to Micah, and he's going to explain how one might file an application to federally register Merlot trademark.
All right, so the first thing that we need to do is we need to choose what mark we're going to go ahead and get this registration for. First and foremost, it has to be a mark that people actually associate with you. The thing that the trademark protects is that association, so that association, having that association is one prerequisite for actually getting that registration. The second thing we have to look at is avoiding likelihood of confusion. That means we have to look around and see if other people have similar company names or similar marks. We can Google it. We can search the trademark has a database. We can search there if there are previous registrations that are kind of similar to ours. And we want to kind of steer away from things that are too similar to stuff that's already out there. And finally, we want to look at the strength of the mark. Now, what do I mean by the strength of the mark? Essentially, it's how unique this particular name is. So there's a kind of a spectrum of the strength of the marks that goes from things that are really easy to register to things that the federal office will not register. Things that they won't register are generic names. Things like dry cleaners, essentially words that are just describing what you do in plain generic terms. If people see the word dry cleaner on a storefront, they're not going to associate with that with a particular company or a source. They're just going to say, oh, that's a dry cleaner. Next, a little bit easier to register, but can still run into some problems, are descriptive terms, things that essentially describe what the product or service is. If you think something like American Airlines, That's essentially telling you it's an airline that's in America. And so these are a little bit easier to register, but you can still run into some problems. You still need to prove that there is actual association, that customers do have that association between this mark and your product or service. Moving farther up, we have suggestive companies like Microsoft aren't really describing what they do, but they kind of bring about an idea of, yes, they create software, smaller devices, that kind of thing. Then you have arbitrary marks, which are real words, but used in a different context, something like Apple for computers, things that people wouldn't really normally associate with computers. And then you have fanciful marks, which are essentially just words that you make up and then attach to your company. The point of this spectrum is to essentially say, how distinctive is your mark? How easy is it for people to create this association between your mark and your particular service? If it's something that nobody's ever heard of before, they're less likely to think of other types of other types of companies or other types of things, and they're more likely to form that connection with your particular good or service. So in our hypo, we have Merlot, so we can kind of think around about what exactly we want to try and register. If we just want to register the name Merlot, spelled like that, M-E-R-L-O-W, we can try and prevent other people from using the word Merlot. However, if we think about it, that's a pretty generic term. It sounds exactly the same as the Merlot wine, which would definitely be a generic term just describing what the product is. So we might run into some troubles with that when we contact the Patent and Trademark Office. We can consider other things. We could add a hyphen in there to make it a little bit more distinctive. We could have the second half of the word in all caps in all of our products. We could have both the title and the tagline in there. And each case, we're trying to make their mark more distinctive, more separate from other existing marks, and something that will be more easily associated with our particular product, and that won't be confusing to other people. The next part of the application process, once we've selected what we want to register, we want to research the current registrations to make absolutely sure that we're not getting into any of the other person's areas, make sure there's no confusion there with already existing marks. We want to do a cost-benefit analysis. Getting a federally registered mark does cost money. There are fees for filing with the Patent and Trademark Office. You might need a lawyer to get through some of the language and some of the complicated procedures involved in getting registration. So you want to see whether or not it's worth it for your business at this particular time to go through with this trademark registration. Next, you want to determine the proper filing basis. What that means, there are two possible routes to federal registration. You can either file a use, which means that you are currently using the mark in commerce. You're selling products with this mark on it. You have it on your storefront, things like that. And you want to get this federal registration protection for this thing you're already using. The Patent and Trademark Office also has an intent to use basis, which means you aren't using it yet, but you're planning to. This essentially allows you to go through with this registration process, see if you can get the trademark, and then after you have that confirmation, you can go through the process of investing time and resources into advertising, into marketing your brand, into that kind of thing. So that provides you a little bit of clarity there. You do have to actually use your mark within 6 months, though you can renew that if things come up. And then the next step is actually use your mark in commerce. Whether or not you're filing in the use or intent to use, you will eventually have to create that association with the mark and your product and service before you actually get the protection. So in our example here, we're already selling on, we have a web page. And so we have a web page that says, Merlot, the ultimate beer wine combo, order yours here. The Patent and Trademark Office will require some proof that you're actually using it in commerce. You can send them a web page where you can order the product, things like that, to actually prove that you're using it. Next thing we need to do is determine which international class we want to file in. The classes are essentially categories of goods and services that you can determine that your product or service fits under. For our example here, we can look at classes 32 and 33. 32 is beers and 33 is wines. So there might be some confusion on, well, exactly which class we want to go into. We could decide that we want protection in both. we just have to like go through that decision and make sure we understand which class we want protection in, which class we want to exclude other companies from using similar marks from us to prevent that confusion. Next thing we need to do is actually submit the application to the U.S. Patent and Trademark Office, pay the processing fee. At that point, they'll look at it, they'll take a few months to review it, and then they'll either say, okay, you have this trademark, or they'll give you an office action, which means they're saying, hey, we came up with these problems. They might tell you like ways that you could potentially address the problems. And essentially from that point on, you're negotiating with the Patent and Trademark Office, essentially talking about what protections you think you deserve and what protections the Patent and Trademark Office thinks you deserve. And essentially going back and forth with that negotiation, how much protection do you get and how much protection do you think you deserve? Once you have your federal registration, you've responded to all the office actions and they have okayed your trademark and put it on the register, you need to go through a couple of follow-up things. You need to update the application with any major changes. If you change what state or address your business is located in, you need to notify them of that. Things like that, just making sure that the application and the information that the Trademark Office has is up to date and accurate. There are also some follow-up filing requirements. If you do the intent to use, you need to file a statement of use within 6 months, that you can renew that if you run into unforeseen delays or things like that. And even with regular registrations, you have to prove continued use after every 5 to 6 years, which comes with another fee. And you have to do a Section 9 renewal every 10 years, which also comes with another fee. And so you're essentially paying the Patent and Trademark Office every so often to make sure that this trademark is being used, that you are continuing this association between the product and the mark. And essentially, if you continue to use the mark and you continue to pay these fees, then that means that your trademark can potentially last forever. There's no lifetime on these, so long as they're being used and so long as you update the information and keep paying the fees.
Okay, so I'm going to talk a little bit about some of the challenges. Mike has already gone through some of them, but some of them need a little highlighting, might not be immediately obvious. So first, we'll talk about the fees. He just mentioned all the maintenance fees, but something we haven't talked about is that those international classes that you have to choose in your application, that is the basis of basically every fee that you have to pay to the USPTO. So what I mean by that is if you had, for example, in our Merlot example, we were like, well, is it wine? Is it beer? Maybe you want protection in both. You don't want any wine to be similar to that or any beer to be similar like that, depending on what the classification was. You may need to do that. What that would do is, since you're protecting it under two classes, that would double all the fees that you have to pay. So for example, this $225 application fee, that would be for a simple mark, meaning it only has one class. It only fits, if it fits nicely into one class or one, it's one good or one service. But say you're a business that does both services and goods, or maybe a good that does a lot of different things and you need protection in many classes, well, this would multiply your filing fees by the number of classes that you're doing. So if you had two classes, it would be a $450 application fee, and all your maintenance fees would have the same effect. They would also be doubled. So this is something to consider when you're thinking, because the number of classes is a very important effect on your fees. Second, filing can be complicated. We did talk about this a little bit. You might need a lawyer to respond to some of these office actions. There will be an examining attorney from the USPTO that will, if they see something wrong with your application, he or she will give you an office action that will say, hey, change this. For example, a common one would be a disclaimer of a certain term, and you're thinking, well, I'm trademarking the name of, like, the brand of my business. Why would I want to disclaim something? Well, all that means is a very generic term within your trademark. If you have maybe multiple words, they will say you have to disclaim the generic term, for example, like a corporation or company, because you can't trademark that. it seems kind of like a no-brainer. That's why you have multiple words, but some of those things you need someone who understands this terminology, and so often people will get a lawyer to help them out. And along with that, a USPTO can deny a registration. They can refuse. And this is appealable. You can also respond to it. Often you would need a lawyer to be able to understand, okay, what are the examining attorney's objections to your trademark application, and how do I convince this attorney that no, my trademark either isn't similar to another trademark. They could object on grounds of likelihood of confusion. They say, hey, we have another federal registration that looks a lot like yours. It sounds a lot like yours. And it's also in the similar goods and services, same classes or similar classes. You have to convince them, well, no, this is why mine is different. This is why, I added this word. It has a different meaning, has a different emphasis. And sometimes you would need a lawyer to write a good argument for you, and then the attorney might be convinced. Another common objection would be just the descriptiveness of your term. For example, the Merlot. The examining attorney would probably say, this is a type of wine. You can't just describe the kind of wine. And we'd be like, no, it's also beer. And so then you would get an argument like that. So that can be a trouble that you possibly need a lawyer to help you with. But it is possible to simply, a lay person to give a response to the USPTO examining attorney with some very practical reasons why your trademark or your business is different than what they had thought it was and what you had written in your application. So it's not necessary to get a lawyer in all situations. Then we do emphasize that you get a lot of protections from a federal register, but even once you get a trademark, other parties, those who have registered, those who have not, can still sue you and say you're infringing on my trademark rights. And this can happen whether you registered or not. If you're doing business with a name or a symbol or anything, you can always be sued by someone if they have a decent claim and say, hey, you can't use that. So this doesn't go away even if you have a filed trademark. But when you have a registration, this increases the presumption that you have taken the right steps. You have evidence that I had an examining attorney who was looking at all the federal registrations, and they think that this is not similar to another mark. So if someone had a federal registration and they came and tried to contest your trademark and say, hey, yours is like mine, you say, hey, well, the USPTO office already looked at this. They are presumably already saw it, and unless they messed up, they didn't think that it was similar. So it does give you a presumption that you can use as an argument that your trademark is valid, but there's always that possibility that your mark can be contested.
Only if it's in the same class, right? And use that example of 33 and 32 and 33 or whatever.
Yeah, so the question is if it's only in the same class. The classes are definitely there to help examining attorneys to determine if the trademark is in a very similar area of goods and services. But there are classes that are similar enough that depending on how similar the name is, the examining attorney will be like, well, 31 and 32, they're close enough, and your name is just too similar to some other trademark. So the classes are there to help you. They're kind of numbered in a way that similar ones are often categorized together. So it's not a perfect system. It's not like, well, my class is neatly in this one, and it's not similar to any others. There's a wide spectrum of how goods and services relate to each other. For example, a trademark in a restaurant and a trademark in food that you buy from Walmart, well, that's fairly different. It's a different class. But some restaurants, they have, like Famous Dave's has Famous Dave's barbecue sauce that they put in Walmart. So there's some crossover, and it can't be neatly divided. So it's one consideration that they're in different classes that you can argue, hey, look, they're different, but it's not the be-all, end-all response. And then on the flip side of there still being the possibility of someone contesting your trademark, you have the responsibility, if you choose to take it, to prosecute other people's infringement on your trademark. Now you have that right. Before you did not. But now you can say, hey, you can't use a trademark that's like mine, and if it's within the geographical areas, if you really do have a good case and you were using your trademark first, then you do have a legal right to enforce your trademark on those that are infringing on it. And if you don't do this, if you don't do anything, there is a possibility of abandoning this trademark. Which basically is like, well, it's a different situation than if you weren't using the trademark. You could still be using it, but if you're allowing all these people to basically infringe on it, and you weren't doing anything to check if there were businesses that had very similar marks, and this goes on for years and years, well, if a situation comes up where there's a lawsuit, the court might think, well, you haven't really been enforcing it. You let these companies go for years and years, and you've basically given up that right. You can't hold on to it forever if you're not doing anything about it. So how would you do this? How would you enforce your rights? As I mentioned, the USPTO office doesn't do anything. All they would do is turn away applications. I mean, part of their job is to look at other registered trademarks in the Federal Registry, and if they see one that's similar to your application, well, they'll turn down the application. So now that you're on the side of having registered, you're at least happy that they are turning down applications that might be similar to yours. You're happy for that. But they don't do anything else. If someone was using a mark similar to yours in another state, even though you have a federal registration and you have the right to make them stop, the USPTO office isn't going to help you with anything. You would have to find it yourself and see the ways that you can prevent them from continuing. So how could you do that? Well, you can search through the federal state registers, and that would be something you did before the application, but you can continue to do it to make sure new trademarks haven't come. And every once in a while, the attorneys that are reviewing the applications, they make a mistake. So you might see, hey, that trademark shouldn't have gone through. That's very similar to mine. You might have just a different opinion than the lawyer, but you can always see these things before they come. When you're searching, and you also have the ability to, for the Federal Register, they give you a 30-day window for new applications that were just approved by lawyers. You can object, and this is an easier way to pursue your rights against incoming registrations before they are officially registered, and this is an easier way than having to file a lawsuit against a registration, but you have to catch it in that first 30-day window. So it might be good practice to look up federal registers every month, for example, to check for the new registrations, make sure that they're not too similar to yours. There are services like watch lists, like Google Alerts, and things to that nature, which instead of you having to search through all these different engines, it kind of does a search for you. It will alert you if they see keywords. So for example, if we had the Merlot trademark, we would put some keywords similar to Merlot, and if all of a sudden these watch lists find a search result that's similar to that, they'll pop up, hey, there's a new trademark, has a name, and it would have to fit some of the searches that you programmed it to make, but that is one tool that can help you instead of you having to do everything manually. And so the main method to actually enforce your rights would be to send a cease and desist letter, and you could get a lawyer to help you with this, or you could do it on your own. Basically, if you find a trademark or a business that's using something similar to your trademark, you could send that business a cease and desist letter saying, hey, this is my trademark. You can show evidence of what you've got and say, you're infringing on my right, and so please stop using that logo or those characters or whatever. And so even if that person, that business does not respond, they don't comply with your request, this at very least would show evidence that you're not abandoning your trademark right. As I mentioned before, you could abandon it if you weren't doing anything to enforce it. So this is a good practice, even if you're not willing to take too many further steps. You don't have the resources to go and prosecute every trademark around. At least if you can send them a letter, show that you're not acquiescing to their using a trademark similar to yours, then this is good evidence that you will have continued to preserve your trademark rights. And lastly, you can enter into litigation now that you have a trademark, and both on the offense, now that you have a registered and you have some rights, and on defense, as I said, you can still have people objecting to your trademarks. And in the same way, many registered trademarks, there's disputes between registered trademarks. And then, as I said, since there's different levels, there's the federal, there's the state, there's the common law rights, sometimes there's battles in between those types of rights. And I want to give a quick example as we wrap up about what this might look like. This is a famous case between two Burger Kings. And so this photo right here on the left of the screen, that is a Burger King in Mattoon, Illinois. And this was opened up in the 50s. And the Burger King from Mattoon, Illinois is not the Burger King that most of you are familiar with here in Omaha. That is the Burger King on the right with that logo, with the restricted logo or a registered logo, and that is a different. That's the fast food chain Burger King. So the two businesses. And the first Burger King from Illinois said, "Hey, we started in the 50s. We were here first. There was no other Burger King before us in this area. So you know what? We want to kick out all the chain Burger Kings from around this area because we were here first and they're diluting our product and we're the real Burger King." Well, Big Burger King didn't like that. So when Little Burger King sued them, they countersued and said, "Hey, well, you guys don't have a federally registered trademark and we are much bigger than you, so we're going to kick you out." So there was a back and forth lawsuit, and this can happen. So the end result of this lawsuit was they both won a little piece of the pie. It's up to you to decide who won the most. But Little Burger King was right. They were first. They were the first Burger King, or at least before Big Burger King. So of their two rights, they have the predominant right in terms of chronology, in terms of time. But Big Burger King had the federally registered trademark. Little Burger King just had the common law right. They were just using it in business and only in this little area in Mattoon, Illinois. So what ended up happening is the court said, well, Little Burger King, you can have exclusive rights to operate Burger King within your tiny geographic area of Mattoon, Illinois, and 20 miles outside of the city. And that prevents Big Burger King from opening any fast food Burger Kings in that area. But you have no rights to Burger King outside that area because you didn't register a federal trademark like Big Burger King did. So it's something to think about. If Little Burger King had the foreknowledge, and if there were federal registers back then, they could have had that trademark and basically been able to, either force the hand of Big Burger King or sell them their trademark for a lot of money. But since they only had the rights to Mattoon, Illinois, Big Burger King's like, okay, you can keep Mattoon, Illinois. We'll go set up shop elsewhere. So as we conclude, there's some resources that you all can look at. So for federal trademarks, the main resource is the USPTO website, uspto.gov, and they have lots of helpful web videos that kind of show you the process if you're interested in that. You can use a lot of free and reduced price legal services. Here's a shameless plug for the UNL Wabeling Entrepreneurship Clinic. We do free services and we help with a lot of trademark issues for our clients. And there's also Micah, if you want to talk about the Patent and Trademark Resource Center.
The USPTO has several different essentially law libraries across the nation that they designate as patent and trademark research centers. The University of Nebraska Law Library is one of those. Essentially, if you go there, the librarians will help you with some information that the USPTO provides to them about trademarks and trademark registration, and they'll also be able to answer questions that you could have for them. And I will also just mention quickly, the USPTO website has a a video series on trademarks. They can be a bit cheesy at times, but they are pretty helpful with providing all the information that you could want about trademarks and more detailed information that we could give today.
All right, now we're going to open it up for questions. Yes.
So when you have a logo, for example, and you're submitting for your trademark protection, for example, our company's Home Care Partners of Nebraska, and then the slogan's a culture of caring. Does it read, obviously it sees the graphic, the look of the logo, but does it also protect the content to the actual slogan, or is it just a graphic? Is it protecting both the words and the look?
Yeah, that's a good question. So there are different types of marks. One of them is a word mark, which would just protect like the content. So if you have the slogan and then nobody else could use the slogan, there could also be, you could also include limiting factors like the specific type of font, but you don't have to. And then there are also visual marks, which could be the logo, which could include text in it if you wanted to, or it could just be the logo. So you could get separate protection for each of those in different types of protections.
So and you're saying you'd have to get separate protection?
You could if you wanted to. If you have protection for the logo with the words on it, then nobody will be able to use the logo with the words on it to be confusingly similar.
Start with that route.
You could, or with
because the slogan can be used in any other way, just as long as it's not in that logo.
Right.
So you have to do them all separately.
Right.
So when you're doing that, my assumption is we're gonna have a different give an application fee for each of them, correct?
Yeah, that's right.
And that's why many people just do a character mark, trademark application, where it's just the name of the business or the brand, and they don't care so much about the graphics.
So all of them that showed up there, I was thinking it through, I think all of them were graphics, right? I don't think any of those top 30 you had up there, none of them had a slogan that went with them, I don't think, did they?
They do have trademark slogans, but their particular brand mostly is with the product name or the company name. I believe like companies like Coca-Cola will have word marks for the name Coca-Cola. They'll have marks for the specific way that it looks. They actually have trademarks for the way that their bottles look, the specific shape of the glass bottle.
The real thing, they trademarked the real thing, and also Coke, with the Coca-Cola. So they spend a lot of money.
In the back.
Where do web domain URLs fit into this whole equation? Is it kind of a combination? Coca-Cola has said Coca-Cola.com is ours. You can touch it. And you have coca-cola.com, and will they come after you for that?
Yeah, so that's a good question. So internet domain names have their own separate regulation, which is confusing and kind of done by the government and kind of not. So the trademark office doesn't actually control the domain names, but if a company is using a particular domain name in a way that would make it confusing with a different company, then they can be sued for infringement. It's a bit more complicated with domain names, though. Yes, sir.
Let's say you have a federal trademark and you're protected that way, but you decide you want to expand into Canada because it's the adjacent market. And there's, for the most part, the language is similar. You still have to go through that whole international process, or are there some maybe easier ways to move into Canada?
So you do not have to, but as I said, you might have to get a lawyer that lives in Canada that understands the law, how to do that. The benefit of that international system is you don't necessarily have to know anything about it, and it could, by good luck, you get it approved, and you would have to pay this international office, a fee. But no, you could definitely get a trademark in any individual country. You do not have to go through any international system, and it might even be preferable. I would think that the fees for the international office they're more beneficial the more countries you're going into. But say you're just doing Canada, has a similar language as you mentioned, it might not be worth paying $600 just for them to help you with that. You might be able to do it on your own.
And other countries might also have common law rights that you don't need registration for. I don't know if Canada has that, but that's certainly something that you could look into as well.
Well, entrepreneurs talk, people talk, and I was told long ago that it's worthless to get a trademark in China because they don't honor them, and do anything with it. So you're almost better off to not submit, because then they don't have something to copy. But
I think there's some truth to that. When I was looking at the international, there was a fee generator on the World Intellectual Property Organization website. And you can notice a trend. The more developed countries, the ones that are, maybe Europe. I listed the ones that I thought were comparable to the U.S. So United Kingdom, Japan, Israel. Those were the fees were similar. They were somewhere between $200 and $400. But if you started getting into some developing countries where maybe there's no real good mechanism. They don't have ways of protecting your rights that much. I wouldn't say China is developing necessarily, but it's a different culture. They do different things with trademarks and intellectual property. It's not such a big deal over there. So you might be right. They might have a mechanism to do it, but as I looked at the fees, I thought it was telling that in some of those countries it was much less to file, because you get less protection. I mean, they need to meet the market demand of, well, there's not too much market demand in this country to file a trademark, so they're going to lower the fee to like $50 or $100 to get some people to be like, might be worth it, but there might not be much that you can do with that.
well, and does everybody have classes for the international, and do they match our classes?
So as I stated, the international classes, it's only the countries that have agreed to these treaties. So there are some countries that are they didn't agree to these treaties. They're not involved with this. So no, nothing would transfer. But for the ones that have signed onto these treaties, then yes, these international classes would be at least theoretically the same. And the way that each country interprets their laws can affect these issues, but broadly speaking, they should transfer if they're a participating country.
You might want to ask if anybody in Nebraska City has a question.
Do you have any questions from Nebraska City?
No, not at this time.
Okay, no problem. Just wanted to give you the opportunity.
Thank you.
Question for you. So in the very beginning, you said we have to use it. And I've had different people tell me different things. What is it? Is it, for example, let's talk about a logo. So I have to use the logo. And is it the logo, or is it the logo with the R and the circle? So do I need to start telling the world, even though our logo's been out there for 6 months, do I need to start telling the logo, it starts today with the R circle? Can you kind of help me with that?
So that's a good question. The R with the circle is something you use only after you get the registration.
Okay. So it started 6 months ago.
Yes.
Okay.
Yes.
Thank you.
Yes, there is. You might see like TM sometimes instead of the R. That's something that you can use before you get the registration to say that you have a common law or a state protection for your mark.
Mm-hmm. TM on everything.
Yes. Yes, the R is specifically for registered marks, and there are actually, I think, penalties if you use it and you don't actually have a registered mark.
So lots of companies change their branding throughout the business's life cycle, particularly in the first few years. They have a great logo or a great name. This is the thing. In fact, sometimes they have that before they have the product or the service. Talk about what happens during the business's life if they go out and file for trademark protection in year 1, and then in year 2 they decide to change their logo's color or shape or something slightly about it, or they decide that maybe they hire a marketing person who says your name is actually really terrible and not getting you the customers you need. How does a company deal with those changes?
So it depends on initially if it's like small changes, like changing the color of the logo or changing maybe the logo would be different, but changing like the color of the font you use for your name or things like that. It depends on how exactly your trademark application is worded. If you specify specifically, I'm going to use this word with this particular font, with this particular color, then you might run into some troubles. However, a lot of them are more generally worded, like we'll be using our company name. It could be in any font, it could be in any color, things like that, especially with word marks that allow for more flexibility. And so those minor types of changes are okay. If there are more major changes, if you like change specific words in the logo or use something else entirely, you might run into some problems. And you probably, and if it's significant enough change, people won't be able to make the jump between the previous logo and the next one. Then you'll probably have to file again and get new registration for the new thing you're using.
So is there any way to amend one rather than filing a new one, or is it always a new one if you're going to do that?
I believe once it's registered, that's what you have. If it's somewhere in the process, you might be able to amend it, but they don't. Again, they don't give you too much leeway once you've actually submitted the initial application.
You can amend the application.
Mm-hmm.
Right, but you can't amend, you really are filing a brand new application if you are going to change it.
Yes.
And what about abandoning? If you with one and now we don't like that anymore, so we go to this one. Can you actively abandon this, or does it just you have to wait out some time with nobody?
Well, when you, for the Federal Register, there's certain year dates that every 6 years, or the first 6 years, you need to file a statement of use. That's partly to get to that question. If you decided after 6 years to stop using it, you could just not file that, and then your trademark would be done for, because you need to keep it up with those maintenance filing. There is also a way to, through the application, say we're no longer using this trademark. Does that answer your question? Yeah.
I do have one more question on the logo with the trademark concept. So when we make application for the registration, do I send in the visual of just the logo with no TM or the logo with the TM? Because I don't want to obviously have to carry the TM and the R, right? So I take the TM off?
Yes, I would do that, yeah.
Okay.
Yeah.
Sorry, I was just thinking through the
It's
application
all right.
process.
No, that's a good question.
Because you know you're going to ask me.
Any other questions? All right. Well, thank you. Oh, sorry.
Make sure that, especially for our folks in Nebraska City and other recording, make sure you thank our sponsors as well before we adjourn. SEC.
Yeah. Well, thanks to the SEC for having us and for putting this on. It was a pleasure sharing what we know about trademarks. We have some resources here at the SEC. Sorry for the people in Nebraska City, but we can send you our slides if that helps refresh your memory on this, and some questions. And you can also always contact the Waveling Entrepreneurship Clinic, and we'd probably be happy to answer your questions, anything you have regarding trademarks. Thank you.
Thank you. You've made a very convoluted topic almost understandable.
Yep, that's the best we can do.
Students with all my little notes. Who are you? No, I'm
All right. Someone who knows what they're doing.